Legislative Freedom of Information Advisory Council to order. I'd like to ask Staff Bernadette Meno to take roll.
Senator Rory Respicio.
Present.
Senator Anthony Ada.
Present.
Senator Tom Ada.
Present.
Sophia Santos Diaz. Absent. Jane Flores.
Present.
Barry Meade.
Here.
Pat Mason. Absent. Rindradi Lintiaco. Absent. Maureen Meritita.
Present.
Jeffrey Marshall.
Gagahallam.
Robert Klinsky. Absent. Troy Torres. Absent.
Okay, thank you. And it's 7 to make quorum, and it's a majority of quorum for all our actions today as a council. The next item on the agenda is adoption of minutes. Members, you have before you meeting minutes dated April 30th, May 20th, and June 3rd. If you recall, all of these minutes were prepared almost immediately after the council has met. However, there was one of our members was concerned with how the minutes were too descriptive of personal feelings, and so that member asked that the meeting minutes just record the actions that were made by the council. When staff prepared the minutes based on that suggestion or that request, the same member came back and said, wait a minute, your meeting minutes should just reflect those actions of the council. And so as frustrating as it may be, you do have minutes before you dated April 30th, May 20th, and June 3rd, all of which are prepared pursuant to Robert's rules that just record the actions of the council. Because after Bernadette made these minutes just the actions of the council, one of our members said that it was not as descriptive enough. And so we're going to take the liberty to present these minutes to the council, barring any concern a member may have, and present these to you for adoption.
Move to approve.
Okay,
All three.
there's a motion by Council Member Meade to approve all 3 minutes before you, dated April 30th, May 20th, and June 3rd, all subject to correction, right? And the corrections will be just technical corrections, grammatical. Seconded by Maureen. There's no objections. Motion is made. All those in favor say aye.
Aye.
Okay, thank you. Now these minutes can finally be posted on the website. There was another concern. We were posting everything on the website, but a member advised that nothing should be posted on the website unless it was adopted by the council. So you can already see where I'm going with my explanation, which will address item 5 under complaints. But for now, I need a motion that we table the Freedom of Information and Open Government Complaints Subcommittee reports, training, seminars, and educational programs report, publication of printed materials report, and website compliance report, only to be able to get right into FOIA complaints.
Motion seconded.
Thank you. Vice Chair, you want to make, I guess motion need to be made first before it's, who did someone make the motion?
You made the motion.
You made a motion?
No, I thought you.
No, I can't,
Oh, you
I'm
can't
chair,
make a motion.
yeah.
I move that we table the subcommittee reports so we can get right into it.
So the Vice Chair moves to table item 4 on the agenda. It's been seconded by
I'll second.
Barry. All those in favor?
Aye.
Okay, all those opposed? Okay, ayes have it. So,
Point of clarification, Mr. Chair. Are we
okay,
tabling
can
this?
you,
Oh, I'm sorry. A point of order, we're tabling to bring back at a later date, or are we reordering the agenda?
that's
Just
good
to be
point.
clear.
We'll reorder the agenda, and given the outcome of item 5 and items 6, then we can always reserve to go back, but I think it's to reorder the agenda for today. It's good. Because we need to just go right into FOIA complaints, and then unfinished business, new business, and we have the subcommittee of the...
Turn it off.
We're reverberating, and it's also So we can, because we have the chairman of the subcommittee on freedom of information and open government complaints here, and if he had something to report after we dispose of item 5, then we'll certainly go back to that. But
Okay, then, Mr. Chairman, I ask that we have a proper motion, instead of to table the item 4, but to reorder the agenda, bringing
Okay.
item 5 up to 4 and 4 to 5.
okay, thank you, Barry, for that clarification. And then, is there a second? Senator Adams. So there's a motion that we just reorder the agenda. That's more appropriate. Thank you. So all those in favor? Aye. Okay, opposed? Okay, ayes have it. Under item 5, we have 3 complaints before the FOIA Council. We have FOIA complaint number 1, McNitch versus UOG. FOIA complaint number 2, Roar versus Legislature. And FOIA complaint number 3, Roar versus Legislature. This FOIA Council, as you recall, has spent a great amount of time with the subcommittee on open government complaints, trying to develop rules of procedure. I want to recognize our subcommittee chair, Jeff Marchessault, for investing the amount of time that he has together with the subcommittee members to try to operate under the rules of procedure that we've adopted. As I understand it, these rules of procedure, which took about 12 hours, right, Senator Atta? All of 2 or 2.5 days in Senator Tom Atta's office, going through line by line, trying to determine the best rules of procedure and the course of action to take in handling all these complaints. As I understand it, based on the rules we've adopted, that I receive all the complaints, that I refer the complaint to the subcommittee chairman to determine jurisdiction. And the subcommittee will meet, determine jurisdiction. If there's jurisdiction, the respondent, both the petitioner and the respondent, will be notified. If there's no jurisdiction, again, the petitioner and the respondent will also be notified as to the disposition of that situation. Unfortunately, in the 2 complaints filed by Mr. Rohr against the legislature, I, along with Senator Atta, who's on the subcommittee, recused ourselves. At the time, there was another recusal by the vice chair, so there weren't enough members of the subcommittee to dispose of those complaints before it. And so procedurally, we're at a quagmire with handling these 2 complaints. On the McNitch complaint, the complaint McNitch v. UOG was filed prior to us developing the rules of procedure. And so, absent any rules of procedure, I instructed staff, and we worked with the vice chair and myself to develop some draft opinions. Those draft opinions were brought forward to the council for discussion and disposition. One member protested that these complaints should not have been disposed this way. These draft opinions should not have even surfaced. And so that put us back to the drawing board. So we went and did all these internal operations, procedures for the Freedom of Information Advisory Council, tried to run these complaints based on the new procedures, and it's been one frustrating process after the other. I'm grateful that our subcommittee chair, Jeff Marchessault, is here, and I sincerely thank you, Jeff, for all your work to try to operate under the guise of these internal operations procedures. Also, within the subcommittee, there was a request for an extension on the first complaint, and although that request for an extension was granted, there's nothing in the rules of procedure that grants for such. And so this is why I decided to call a FOIA council meeting to bring all these matters back to the council, because my thinking in how a legislature operates is that if a committee of a legislature has some challenges before it, needs some assistance, that the full legislature can step in and provide those remedies. And so in this case, the subcommittee has a huge challenge before it in that there are 3 complaints and there's not enough members of that subcommittee because of recusals. I certainly have recused myself on the 2 complaints, the second and the third one, and the subcommittee predetermined that I should recuse myself on the first complaint. And so I didn't want to object to that predetermination, and so this is where we stand. And I'm bringing these 3 complaints back to the full council, recognizing the tremendous challenge that was placed before the subcommittee. And as I understand it, Jeff, something's got to be done, right, outside of the subcommittee? And thank you for being here.
Yeah, because the subcommittee is just too tied up with perceived conflicts of interest. I know that not everybody agrees that they've conflicted themselves out or that they should recuse themselves, but we agreed as a subcommittee, both loosely and in subcommittee meetings, that it's probably best that these issues be brought before the full council.
Okay, thank you, Jeff. So as chairman of the full council, I'm bringing these 3 complaints forward to the full council for discussion, disposition. Vice Chair?
I too would like to thank Jeff for all his work and the work on the subcommittee. A lot of information has been filed with regard to the first complaint, McNitch versus UOG. And as I understand it, was Dr. McNitch's response ever filed? Did he ever meet the deadline to file the new?
The new deadline, my understanding was that he met that deadline immediately.
Okay.
Because he was there
Right.
at that last full
all right,
meeting,
right.
at least with the council.
Yeah. Okay. And, for purposes of discussion, both sides have obviously stated their own cases. And with regard to open government, I actually did some research also on the issue of whether faculty senates are supposed to be under the open government law. There are some cases where they say faculty senates are under the open government law, and some cases where they say they are not subject to the open government law. So it goes either way, but having been, a previous Sunshine Award winner and president of MSPJ, I would like to say that I think the council should, because we are with freedom of information, we should advise all committees, subcommittees, senates, whatever entity you are that relates to the government, to be open with regard to your work, with the exception, of course, of the exceptions that are available in the Sunshine Law, which have to do with personnel matters. So that would be my recommendation to state to the Faculty Senate and to Dr. McNitch.
Maureen?
Could I just go back? You said that Ron McNinch met the deadline. Where are we in that procedure, actually, though? Was UOG then supposed to?
Yes, they did.
Okay.
They sent a response to it.
So we are where we should be. We have all the responses. Sorry, I just wanted a clarification on
Well, we
that.
have a representative from the UOG Faculty Senate that's saying that they were not notified of Ron McNitch's response. Did you?
There wasn't a requirement of making,
Yeah.
deadline set, and we're part of
Can you come over and... I'll entertain this discussion because, again, it's a good
course.
case study
Of course.
on how we
Yeah.
can refine this process.
Can you introduce who's going to be speaking?
Yeah, this is Bernadette Meno, who's been assigned lead staff for the FOIA Council.
Thank you. Mr. Chairman, in the subcommittee determination, when they set the deadlines were given, but there was no requirement then allowing each party then to get a copy of the response again and then review it. And it was just, here's your deadline. And we do have the documents from both parties, including Dr. McNinch's response, which came the same day, and UOG.
I also want to just make a point of clarification. I think, Mr. Chairman, you stated earlier that once a complaint is made, if we determine that we do not have jurisdiction that we notify both parties. As I recall, and I don't have the rules right in front of me, we don't notify the party that's being complained against, because if we decide that the
No, you
complaint does
notify
not
the
have
petitioner.
merit on its face, then there's no reason to entertain it at all.
You're right, I'm sorry, we notify the petitioner.
Right, just the
Yeah,
petitioner.
Okay.
With regard to the faculty senate's notification that they were not given a copy of of Dr. McNinch's response, what does the council have any opinion as to whether or not we need to give everybody a copy of everybody's response? And then does that lend itself to, well, we want to respond to the respondent, and then we want to respond to that response, and then we go back and forth and back and forth?
Barry and then Jeff.
Blow up on us?
Okay. If I can remember correctly, we held a subcommittee meeting at which Dr. McNinch and we had a representative at the time of the Faculty Senate was present. And the Faculty Senate had requested a delay in their response until, I believe, 1st of September. Correct me if I'm wrong.
That's correct, yes.
There was a request that it be delayed until the 1st of September, of which time the faculty would have all returned to the university and they could take it up as the Faculty Senate. That request, that request was granted. At the same time of that meeting, because of all of the things that the chairman had explained about the delays in the process of getting the procedures set and everything else, Dr. McNinch was given or afforded the opportunity to, I believe, resubmit or stand with what he had already submitted. My opinion would be that though he did not make any response by the 1st of August, if that was the date we actually set. I don't have my notes in front of me on that, but if he didn't, then I would assume that he is satisfied with what he had already submitted, and that we would be holding for the Faculty Senate to provide their, if you will, official input, though I'm looking at a letter dated June 21st from the Faculty Senate that includes what they believe to be their position. It includes a letter from WASC. It includes the reaffirmation of accreditation visit. The one thing that I don't, scrolling through here real quickly, I'm looking for the resolution that was passed. Oh, I have it right here. It also includes what was numbered Resolution 0101, where the university, relative to approving the charter of the Faculty Senate, so that was forwarded. So for me personally, I have, and I've reviewed all the documents that were submitted by everyone, and me personally, I would be prepared to render what I believe would be my decision in the whole matter. I don't feel that because Dr. McNinch did not submit something on August 1st that we should lay this aside, because he did originally submit, and after the procedure was followed, he did submit information. UOG acknowledged, the Faculty Senate acknowledged that information. They, matter of fact, did a FOIA request to have the information from Dr. McNinch provided to them. That information was provided to them. They did make a written response, which at the time, I'll be honest with you, caused me to say, why do we have to wait till September? But I was in agreement with going ahead and doing that, having history of background in those areas, and I agreed to do that. So I have not seen the official response from the UOG's Faculty Senate that they were given an extension to provide till September. So if we're going to hold one, we should hold two. Thank you.
Have we gotten anything from UOG since September 1st? Yes, yeah, everything went out. Yeah, we did.
That's right, but we never got what we were told we were going to receive by August 1st.
Mr. Chairman, I would remind everyone gathered that there is a period for public comment. Maybe we should just follow the order. That was the thing that I wanted to address. There were two things. One is that I know there's some consternation and confusion in the public hearing room, but there's an opportunity for public comment, and I would just remind people that they will have an opportunity to comment, so we can just stay on agenda. And then the other thing is that part of the confusion that ensued at the subcommittee level was as a result of the fact that we kept receiving and accepting information ad infinitum, especially from one petitioner. And it made the process more confusing, especially because we had agreed to accept that information and had agreed to receive multiple complaints. So it was a great difficulty to sift through all of that information and find out where we were. So I think what we decided, at least informally, is that we need to cap the information that we receive so we get it all at once and can review it if there are any attachments to the original complaint form.
Well, this would be a good opportunity to recognize the vice chair to begin a discussion on how we can streamline the process to receive complaints and be able to dispose of them in a more timely manner. The whole vision for a FOIA council was to make government open and accessible to just any concerned citizen. I think we've went back and forth about how these procedures have made it so that it's more like someone would have to go to court just to get justice, and that's all of you were appointed because of your expertise in the open government area and your work over the years to keep government open and accessible, and that's why I continue to recognize you, Jeff, for trying to operate under these rules that are so cumbersome and does not provide for that openness in the process. As we could see from the discussion on complaint, the first complaint, I'm not even prepared as chair to dispose of the complaint based on a motion that either Jane or Barry would make. I want to recognize the vice chair to maybe talk about how we can better streamline this process and then maybe run all these three complaints through that process.
All right.
Jane?
Well, at the risk of the complainants and the respondents being very frustrated because of the time that it has taken to do all this and the vested interest that they both have in this, just a reminder that this is a volunteer council and that this is also just an advisory. There is no
force of law
or there will be no repercussions for either entity, with the exception of the fact that there should be, afforded more open government, because that is what this council's whole entire mission is to provide more open government. But and I think that both Dr. McNinch and the UOG Faculty Senate have given us enough information that if everybody needs more time to review it, I would say, okay, if you want to review it, then we can do that. But I would say that at the next full council meeting, we have to make a decision, because it's getting to the point of ridiculous. So, but having said that, I just emailed the subcommittee just a streamlined process for making complaints, just so that we don't have to have this sort of quagmire that we have had in the past with the meeting of the very complicated minds that we have on this subcommittee to put things in a more complimentary light. But so what I would like to propose is that when someone files a complaint with the FOIA council, that complaint be disseminated to the full council by the legislative staff, by your staff, Senator. So the complaint is disseminated to the full council by your legislative staff and placed on the agenda for the next meeting. Now, the staff should also transmit the complaint to the respondent because then the respondent can have a deadline, and we should give a deadline of 2 weeks, and that's it. Because so we don't have to have this be dragged on and on and on. Just a deadline of 2 weeks. That's your response. Now, if the complaint happens in the summer, for example, with this, and the staff and the council wants to say, okay, look, if most of the people are on vacation and we want to just table this until we know that there can be a response, we can table it, and we just table it. But so the respondent would get 2 weeks. The staff. In the meantime, the council members can review the plaint, and each member can either research it on their own or ask your staff, Senator, to research it. The research should be forwarded to all the council members. Whatever you find, forward it to everyone, or bring it to the table for the next council meeting. At the meeting, and everybody review it before then, so that we don't have to have people just sitting here reading, and be prepared to discuss your findings. And then at the meeting, the complaint, the response from the respondent, and the findings are discussed, voted on, and then the staff can post the vote and the findings on the website, notifying the complainant and the respondent. And that way, I think it would just streamline this process.
And this is similar to what Barry tried to suggest early on. I'll entertain some discussion.
Yeah, so Barry, do you have anything to add? Because I think that half of this is yours.
I think in the one that I had submitted, I had put a few more timelines, because I felt that it was necessary to have the timeline so that the council itself would be bound, if you will, but also that people that are submitting the complaints can feel confident that the complaint would be dealt with and handled in a timely manner. So. But no, I thought about that at the very end, but I see where the findings would be posted on the website, and notification would be to the complainant and the respondent of those findings. And the only thing, I'm good with this, the way it reads. I like the idea that, okay, we could have staff research, but I also like the idea of having the council members themselves do the research, so that they're, attuned. We can always take recommendations, but doing it ourselves, sometimes it's better. We have a better understanding of things.
Right.
When we say down here, staff researches and sends findings to all council members.
Just the research that the staff has done, not the opinion. We're not asking the staff to make an opinion or anything. Just say, for example,
okay, so findings is the research. Okay.
Faculty senates, are they find instances where faculty senates are open and where under the open government law, and where faculty senates are not under the open government law.
Yeah, so everybody comes prepared. And it's evident. There was something written, placed on the agenda for the next meeting.
Now, the only thing is, if the meeting, if you call a meeting, like senators say, we call a meeting on the 15th of the month, and we get a complaint on the 10th, then that doesn't give the respondent the 2 weeks. So then that complaint would have to be addressed at the next meeting. The next meeting. Yeah. So to give the respondent 2 weeks. And I think 2 weeks is ample time.
Or we can always call a meeting 2 weeks after we receive the complaint.
Right.
So
exactly. Thoughts, senators?
I would just make a little change to line B then to clarify that.
Do we need to have a provision in here that just eliminates the complaints subcommittee?
Does the complaint subcommittee need to do anything else? I mean, is there?
Well, it sounds like the work of the complaint subcommittee would just be transmitted to the full body, right?
And that was, my whole concern is that the complaint subcommittee was doing, the brunt of the work of the council and just making a recommendation to the council, and whereas the full council should be making the decision. Whereas it sounded like the way we were doing it, the complaints subcommittee was making the whole decision.
That's right. Well, at least the full decision on whether or not the case had merit.
Right.
Right.
But I think that that's something that the full council should also decide.
I don't have any objections to that.
Well, and since if this is going to be taken off from your plate, Jeff, then maybe we can convert your subcommittee into the subcommittee that's supposed to be looking at the current open government law and make recommendations.
It sounds good.
Yeah.
I mean, you're the subcommittee chair, Jeff, so you decide.
That's fine with me.
Yeah.
And I'd like to call a meeting, and I'll do it outside of this,
Yeah.
but to discuss that with our group.
Now, do we want to address, Senator, did you want to address the complaints right now, or did you want to, is everyone prepared to, I know you had said you're not prepared to vote on these yet, or?
Well, first if there's support for what you're proposing, that we revise our rules of procedure and that
To simplify and
replace
streamline
your-
the process?
Yeah, 15,
Yes.
3 pages into 15 lines. I'll
Yeah.
entertain a motion that we do that now.
Just one more thought. We might, when we're deciding on the rules, are these the rules
This will
complete?
replace the
Are these the
rules.
complete rules?
This was just a motion to streamline the process. I mean,
There are some aspects of the
Yeah.
rules that we adopted that would probably be added to this. That's all I have to say, because it takes care of some processing, what's going to go on the forms and that kind of thing, how we process forms, that's all. But I think as an overall,
I think the
overall,
forms
this is
could
good.
stay the same.
Right, okay.
The forms can stay the same.
Yeah, she's not addressing.
Yeah, I'm not addressing forms. This
Okay.
is just,
Wait.
yeah.
Yeah, the forms are another entirely different matter, but this will replace all the procedures.
Okay.
The internal operating procedures. Yeah, and just one correction. Complaint disseminated to full council, and I think you need to put by legislative staff in there.
Barry, did you have a suggestion? So basically, if these rules are adopted, it'd be a very streamlined process. As chairman of the FOIA Council, I would receive every complaint, have staff disseminate it to the council members, and you would be prepared within 2 weeks to come to the council meeting with your findings
Right.
and with your decision on whether or not that was indeed a violation of the open government law.
Well, you're giving the respondent 2 weeks, so that
Yeah.
maybe,
A little
a
bit
couple
longer than
days after that to read the respondents.
That's right, 2 weeks.
Go ahead.
I'm fine with a simplified scope of procedures and complaint process. There's just one section here that seems a little woolly. Council members review complaint, which is fine. Each member can either research it on their own or ask staff to research. So if nobody researches it, then it would automatically be researched by staff, and I mean, we're giving ourselves a short timeline, which is fine, but then, if people are traveling or whatever, then it needs to be very clear, I think.
Yeah, you're right, Maureen. Ultimately, it would fall on the council staff to provide the kind of guidance that the council may need.
Okay.
And then each member will make their own decision. Yeah.
Do we need to add any clarification language to that?
One point of clarification, if I may. One thing that came out of all of those meetings that we had was this idea of frivolous complaints. I would just add something in here that allows us to dispose of them. Sometimes something might come in that just on its face looks frivolous, and it looks like somebody is just trying to sling hash at the other party. So I would just add some sort of language there that allows us to stop that, because I don't want to sully somebody's name and get it out in the public just because somebody has some sort of personal agenda against someone else and there's no substantive basis to their complaint.
Senator, would it be okay with the council if the council gets this by email and then we just take an email poll, say, what do you think of this? And then everybody just emails yay or nay, I don't think this, and we do it that way?
Or what we could do is adopt what you have, and then we can also make amendments to it. We can make an amendment at the next meeting.
Barry, no.
Barry.
Okay. I have internal operating procedures for the Freedom of Information Advisory Council. I think we can pretty much incorporate what's written here into Section 6 of the internal.
The 6th page.
The internal operation procedures. Section 6 is disposition of petitions. It starts out exactly the way you have this here. A proceeding is initiated by the chairman upon receipt of the petition. Then upon receipt of the petition, the chairman shall assign the number, shall give notice of receipt to the petitioner and council members, and forward the petition to the subcommittee. By eliminating the last 1, 2, 3, 4, 5, 6, 7, 8, and forward the petition to the subcommittee, by eliminating that and replacing it with what Jane suggested here, where it's sent to the full council. And then it goes on saying there shall be no ex parte, fine. Upon receipt, the petition of the chair, the chairman of the subcommittee, so what that portion can be
Chairman of the council.
Amended. So maybe what you could do, Jane, or someone could do, is take the internal procedures and incorporate what you put here into that. What that would do, by amending this, it would, one, if the goal is to eliminate the subcommittee, it would do that because this is what gives that subcommittee its authority. So we would be able to you would do two things. One, streamlining the process, including it in the internal procedures already established, and doing away with, if you will, the subcommittee. And I think that may be the answer to what we're all talking about doing, because it even talks about the council recommendations as to how they're disseminated and where they go, and in line with the resolution which says we need to make those recommendations known to the legislature. I think if we just remove the word subcommittee where it appears, and that work, and make it incumbent upon the entire council, would be might be the way to do it.
Do you want to make a motion for that? I mean, that would be fine by me.
It makes sense.
My only concern is that if we're going to do that, then I just realized that we're changing these procedures and we don't have all the council members here. So I would think that we would not make any kind of decisions today on these complaints without having the full council notified that these are now the procedures. Here's all the information. Come prepared to make a decision at the next meeting.
Well, that's why my suggestion was, depending on on how your proposal is handled, we might have to run these complaints through the new procedures, just so that it's fair for everybody.
Okay. But we've already got all the information from the party and the respondent.
May I suggest, Mr. Chair, then, that either Jane or since I'm the one doing the talking, I would take the internal procedures that have been established. This was established on May 29th, by the way. Take these internal procedures, incorporate Jane's suggestions into those procedures, formulate that as a draft for dissemination back to you, for you to send out to all the members for their review, to come prepared to the next meeting to move on that.
Is that a motion?
So moved. Is that a second?
I second that.
Okay, it's been moved and second. All those in favor, say aye.
Aye.
Aye. Opposed? Okay. There's no objections.
Mr. Chair, I would also like to suggest then, in light of that, I would like to suggest that we not forego the complaints before us now. Those complaints have been disseminated in line with the procedures that were established at the time.
Okay.
And I did stand corrected. The UOG response from the Senate
Yes.
is the 15th of September, which is today. So, and I think we have that today. No. Okay. So,
It was
but
submitted.
I don't see any reason why. And I'll at this time say I agree with. And I sent the email the other day, and I agree with you to unrecuse yourself from the B and C.
Yeah. Right.
I understand what it is, and I had a discussion with the chair on that. But I think we should still handle these three the way we are, because to continue to delay,
Right.
it doesn't do
Okay.
the complainant,
Yeah.
the respondent,
This
or
is true.
anyone any good.
It's on the agenda, so we'll
Okay.
go back to item 5.
Thank you.
The first complaint, FOIA 2014-1 McNitch v. UOG. Vice Chair, so I guess as it stands now, these matters are before the subcommittee. As I explained, the subcommittee's challenge to
Yeah. I wish I had all the
Bringing it-
documents in front of me because I reviewed them,
bringing
but
it
I
over to
don't
the
have my,
council. But now
notes.
the council is taking these 3 matters, and we're going to dispose of them today, hopefully. So is there a motion on a final disposition for the complaint, the first complaint, and the position of the council?
Mr. Chairman, given the amount of time that has passed, I think we should either take a recess, review the documents, or meet again, because I certainly would benefit from that.
Okay, and also for the second and third complaint is there a motion that the council receive all the 3 documents? Because as under the current rules, the documents were not supposed to go beyond the subcommittee unless the subcommittee determined jurisdiction and then provided a recommendation to the council for final disposition.
Well-
But if you tell me that you want to see the complaints, I made copies,
For
but I
the-
didn't release it until.
Right. For the second complaint, the first complaint, there are quite a few documents, but for the second complaint, one of the reasons why I was supposed to recuse myself was because I felt that this was just a procedural, that Mr. Rohr filed a FOIA complaint because he said that the legislature had called a session, and which is, according to the legislature's rules, the speaker is allowed to call the session with a 1-hour notice. Correct? Hello? 2 hours. 2-hour notice? Is it 2-hour notice? Okay. 2-hour notice. And normally, the session is called days in advance, and the agenda is set by the Rules Committee. And then the Rules Committee puts the agenda on the website, correct? And then the public knows what is going on. Well, when at this particular time, the session was called with a 2-hour notice, and there was no, I don't know if there was reason given for the session being called and disseminated the reason was not disseminated to the media, and I think that was Mr. Rohr's complaint, correct? And then when that happens, the legislature's procedure is to set the agenda right away and then put it on the website. And his whole complaint was that, well, if you're setting the agenda while you're in there, then nobody knows what you're really talking about until you're already in session, which is a very valid complaint. Correct? I mean, well, I suppose I shouldn't be looking at the 3 people who are involved, so I'll just look at the 3 people who are not in the legislature. Correct. I mean, the basis of his complaint was that the senators should make known what they're talking about in the session before they actually go into session.
That was my understanding.
That's my understanding. So I was just trying to tell him this is the procedure that they have set. And, while I think his complaint has merit. The procedures, I think the only thing that this council can do with the three senators who are involved, because they're senators, having had to recuse themselves, is to recommend to the legislature that if you are going to call a session with only 2 hours notice, that you tell, you disseminate to the media right away what that purpose is going to be. Either that, or you give a little bit more advance notice of calling session.
Okay, at the
So
risk.
I mean, but that's something that the legislature, we can't determine that. We can only make a recommendation to the legislature.
Jeff?
At the risk of going out of order here, Mr. Rory is here, and I know I wanted to wait for public comment because we hadn't gotten that far yet, but maybe it would be in order for us to call upon him as a member of the public to clarify the purpose of his complaint?
Okay, well, if we're going to do that, then we might as well move public comment up and allow UOG to have their public comment also. So do I make a motion to move public comment
Well,
up?
I guess my sense is that this council wants to address all three complaints today, if possible.
I think so,
Yeah.
because people have waited long enough.
Okay, of course, and I don't object to that. And just for the record, we've recused ourselves, the three of us, on the second and third item, so I'll defer to you to shepherd us along on those two cases. But go ahead. You want to bring up McNitch v. UOG first?
I make a motion that. Do I have to make a motion to reorder the agenda first? Is that?
I actually I think I need to make a point here. I did not have any intention of being here today. I actually have to be someplace very soon. If we open it up for public comment, I'm not sure we're going to have a quorum to take any action.
Yeah, you're right. You're right. So what are you suggesting?
Well, I think we wind up being stalemated. I suggest that I think what we can do is call another meeting for another day and make it soon, but I'm all for opening it up for public comment.
Okay, well, then we're going to have to make a decision at that meeting. So if everybody needs to make sure that they
I'm
can't
looking
leave.
at this Thursday at 10 a.m. I was going to propose that we recess until, if your schedules permit, this Thursday at 10 a.m. we won't adjourn. We'll recess, and which is still
All right, do we want to do public comment now or then?
okay. Barry, you were going to say something?
They're both here now, so,
I'm fine with that, yeah.
all right.
Okay, let's bring up the first one.
All right.
Maybe what we can do is, because the University of Guam Faculty Senate had a deadline to submit today,
But they already
and their
submitted.
representative is here, I think
Yeah.
maybe the representative from the Faculty Senate would be able to provide what input he's brought. He came down.
All right.
I would really appreciate to hear what he has to say.
All right.
And then, as far as the two complaints from Mr. Rohr, the first one, I'm pretty clear on, but the second one, I'm in question as to which session he's talking about.
Okay, well, we'll bring him up too.
When I read through that, I didn't see what was the date on. Is it the same one or is it a different one?
We're bringing
so
copies
we could hear from him
We're bringing
second.
copies of the complaints also,
Okay.
since you guys asked
Yeah.
for it. Yeah.
So, Mr. Chair, if we
Jeff,
could hear
are
from
you-
the
are you
University of
coming
Guam
back?
Faculty Senate first, please.
He must
I
be
guess he
coming
just
back.
went to get water.
Oh, okay. Okay, well, so our
Go ahead, I'll let you lead the discussion.
Our procedure right now is going to be that we are going to call up these gentlemen for public comment, recess until 10 o'clock Thursday morning, and then make a decision.
10 o'clock Thursday.
Is that,
Well, we still have a quorum, and if you're prepared to make the decision today, well, all we need is 4 votes, really.
okay. Jeff, can you, yeah, okay. You have to be.
Yeah, I can be here. 10 o'clock Thursday? Is that right?
Yes,
Yes.
okay. All right. Okay, so let's call up from UOG. Come on up. Come on up. Come on down. Come on down. Please identify yourself for the... Yeah, turn on.
There we go. Thank you. I'm Dr. Kyle Smith with the University of Guam Faculty Senate. I'm the chair of the Standing Committee on Institutional Excellence, and I also was chair of the same committee in the 13th Faculty Senate, which is the focus of Dr. McNinch's complaint. One of the things I want to mention first off is that you don't have the Faculty Senate's full response to the complaint, and the reason that you don't is because when we were notified that that the subcommittee had decided in June that they had jurisdiction, we were given a deadline of 1 week, that is 7 calendar days, to prepare a response. 1 week.
But we realized that we
of course.
extended that. Yeah, so.
We appreciate the extension, but what you have in front of you is only what it was possible for us to prepare within 1 week. And the reason is this. I think that the assistant, among other things, will be distributing copies that I brought here. You see, we were informed by the subcommittee that both the complaint and our response would have to be resubmitted because they were simply too long, among other things. Dr. Getzford was the senator available at that meeting, and so he was told that there's just too much documentation there, that a lot of things would need to go in appendices. We're faculty, we're used to that. You know, if you ask us for information, you get a lot, but we usually put it in appendices. So anyway, that Dr. McNinch would be given the opportunity to resubmit with a deadline of October 1st, and that the Faculty Senate...
August 1st.
Oh, thank you, of August 1st, stand corrected. And the Faculty Senate, since we'd had only that 1 week in the summer to try to respond, which we did, you know, we sent our position as best we could summarize it in those 7 days, that we would have until September 15th after receiving Dr. McNinch's revised petition. And since, because we received nothing as of August 1st, and because we received no reply to multiple emails to the subcommittee requesting an update on where the complaint stood, most of our Senate Executive Committee had concluded that Dr. McNinch must have decided not to refile. And in fact, explicitly in email messages to the subcommittee, Dr. Getzford, the Senate President, said, we haven't heard anything, we don't have any revision, we're ready to reply by the September 15th deadline, but we need to see what the revised complaint says. If we don't hear anything, we're going to assume this is not moving forward. And there was no reply, no email, no written reply to that whatsoever. So again, all you have in front of you, it's not the Faculty Senate's entire case, it's what we had 1 week to put together, and we're here to work with you. I mean, we want this resolved as much as anyone.
So Dr. Smith, what would your suggestion be?
Well, I would recommend, first off, that after I finish my remarks, that Dr. McNinch be given a chance to state the timeline as he understands it, because he's just as much entitled to comment in the public section as I am. If the rules have changed, okay, then we need adequate time to respond, not just the original 1 week enabled written response that you have. What we were originally told was that the subcommittee would review our revised response to the complaint and render its decision, which would then go to the council as a whole, whom we would have a chance to address before any final disposition. The rules...
I don't know that the
rules keep changing. I mean, originally, the first we heard of this was when a draft complaint was published in the or a draft decision was published in the Marianas Variety and online with the Pacific News Center. We'd never heard of it before that time, and we'd never been consulted. The subcommittee did the right thing. The council did the right thing in nullifying that draft opinion and then consulting with the Faculty Senate. We met our 7-day deadline. We were told that we'd need to resubmit, and so would Dr. McNinch. It's imperative that we be given that chance to do what we were told we were going to get to do. The Faculty Senate, 13th Faculty Senate as a whole, has never been consulted on this because most of them were traveling, as we said at the time, and because we'd heard nothing from the subcommittee since August 1st, we thought it was dead in the water. I advise the Senate Executive Committee, don't assume that. Talk with the subcommittee chair, talk with the council. Don't assume anything's been withdrawn. Let's work with these folks.
Well, wasn't Dr. Go ahead, Barry.
From the minutes of July 1st, 2014 meeting, Bob Klitsky made a motion that the petitioner be required to submit additional, not an original complaint, additional pages no later than August 1st. That goes to what I said earlier during this meeting, that since we haven't received anything, then I would assume there is no additional. And respondent be informed to submit theirs no later than September 15th, 2014. Jane Florida second. Motion passed unanimous, and UOG Faculty Senate was present and represented at that meeting and knew of it. So to come today saying to me what you're saying seems to be a little contradictory to what the person, I forgot his name, I'm sorry.
Dr. Getzfried.
That was at that meeting that heard what was said. So consequently, my assumption then and today is that the complaint that was filed by Dr. McNitch in its original form,
He did not.
that Senate has a copy of, that asked for an extension to and was granted to respond to, has been satisfied.
May I distribute Dr. Getzfried's 2 email messages that went entirely without response to the subcommittee, which will clarify what the council member is asking for. That isn't what happened.
I have
Okay,
I have those emails. I read those emails.
Okay, well, the emails made it clear that we were wondering what was going on. Was the case going forward? Had the subcommittee decided to drop it? Simple decency as well as procedure requires a response. We got none. We didn't know that this was, we had no idea that this was coming up, possibly for a vote or action today. And the members of the 13th Faculty Senate who stood accused, but in the summer did not know that they stood accused, have never had the chance to respond. All we needed was confirmation from the subcommittee chair that this was still an active case. Dr. Getzfried's emails make that abundantly clear. It is not conscionable, nor anything other than Kafkaesque, not to communicate with people who've been accused and then suddenly decide that the matter is going to be decided at a September 15th meeting that most of them knew nothing about, that this would be decided on today's agenda. It simply can't be done that way. We would have worked with you for September 10th. We would have worked with you for September 1st. We would have made an August 15th deadline. But you can't keep changing the rules and the deadlines and then say, oh, we've decided we're going to do it like this, and it doesn't matter that we didn't communicate with you.
If I may finish, Jane, I don't think that the agenda says that there's a decision to be made. And based on the conversation that has ensued during this meeting, it is not, I don't understand it to be where we're going to make a decision today. If the Faculty Senate was given a deadline of today to submit their response, it would seem to me, and it would be impossible for me, to make a final decision until I had read that entire response. So I think your assumption of a decision being made today without input from the Faculty Senate is a little ahead of its time. I don't think that's the case.
On the basis of words from the chair, are we ready to dispose of these items today? The question is dispose.
It was a question.
Okay.
It's a question that I think I'm answering for him now. No.
So is your proposal
therefore, as I said earlier, do we have the response from the Faculty Senate that was requested and deadlined for today? And the response I get from that is no. The only other confusing issue here is this. You weren't present at this meeting, but you're present today. Another person was. We've gotten responses from various people of the Senate that seem to all be speaking, and I have them on my iPad, as to this whole thing. So I think my fellow members might agree with me that I would be willing to forego the response from the Faculty Senate until Thursday, so that we would be able to disseminate at our continuance of our meeting on Thursday that information with which we could then go back and review, of which we could then, the chair could call a meeting, and we could bring to final resolution this issue.
Dr. Smith, does the Faculty Senate now know that there is no additional response from Dr. McNitch? This is his response is this, and you have that. So
the Faculty Senate never received a revised response via the
There was
subcommittee
no
chair.
revised response.
But we should have been notified
Oh,
that there was no
was.
revised response.
Oh,
If there is a
everything
revised
is in?
response, we never got it. We got no communication from the subcommittee chair whatsoever on that subject.
Well,
Today's meeting was by the Open Government Act announced accordingly.
Correct.
you now have the revised response, so I think that it would be incumbent
Correct.
upon the council to give them a little bit more than 2 days to make a response.
Well,
How long do you need?
I need time to talk with every other member of the 13th Faculty Senate, those who stand accused and were never notified that the case was still active.
Dr. Smith,
2 days, 2 days won't do that.
Okay, how long would you like to have?
3 weeks.
You know what? I have another
Okay.
question.
All right. I am willing to give as much time as they need because they're the ones who stand accused. So if they need 3 weeks to respond to it, then
I have a question. This is from the University of Guam Faculty Senate Executive Committee, Nicholas
Gets for it.
for the committee. Attached to this is a 3 1/4 page response titled Senate Executive Committee Statement to FOIA Subcommittee. And it goes on and on about need for fact-finding, false statements, relevance, on and on about the comments to Dr. McNich's remarks, state court rulings, AAUP subcommittees, on and on and on with all this information. Then, following that, we have a memorandum for the record to whom it concerns with the origin of the University of Guam. And I show this in written because I have it on my iPad also. And then we also have the resolution and everything else. And that information was all provided by the Faculty Senate. So my question would be, what would be addition to that would take 2 weeks to provide?
The document that you're reading from also specifically states that it was prepared in haste in response to a 1-week deadline and specifically requests an extension. What more is needful? A number of things. For one thing, apparently some council members are under the impression that Dr. McNinch was a senator at the time that he was excluded from the executive session. This is not true. He was a senator nominee for interim senator. The executive session required action on multiple faculty nominations, not only Dr. McNinch. I left the room myself when my wife came up for nomination as a interim member of the Promotion and Tenure Committee. We need to respond to the factual inaccuracies that we're hearing, not only outside, but I am sorry to say, on the basis of this meeting, from within the committee. I applaud your service. I applaud your willingness to uphold standards of free information, transparent government. We share those values. It is also the case, as that original document makes clear, that there is a trifecta of competing interests here. They include the right of the public to know. They include the right of the ability of the university to function, for example, to conduct searches, and the privacy of the individual, as specifically indicated in the section of the Open Government Law that refers to decisions on appointments as being valid for executive session. There are a number of misconceptions that have apparently arisen through the process, and we need time to reply to those.
okay.
One last point. I also want to convey particular appreciation and admiration for the fact that at least one member of the council has been doing a lot of research into how other jurisdictions throughout the United States have dealt specifically with this issue. The blanket application of open government law to institutions of higher education is not a simple issue. It has required decisions from attorneys general again and again and again to resolve. What constitutes a public agency? What will be the effect on universities to function and review candidates if they must open all deliberations as well as votes to the public eye? A number of cases have addressed this, as Ms. Flores pointed out. Sometimes they've come down on the side of saying the Faculty Senate is not a public agency and is not subject to these requirements, and for good reason. In other instances, especially those, for example, in the state of California, where the Faculty Senate was created by the Board of Regents, we were not. We were neither created by the Board of Regents, nor did we wait to convene as an organization for their permission. The Board of Regents recognized us as distinct from the faculty union. That's what it does. It doesn't set a mandate. These are complex issues, and they require time, especially among all of those accused, once they know they are accused of having done something wrong, to respond.
I do want to just comment, Dr. Smith, that in the research that I've done, even if an agency is a government agency is required to be bound by the open government law, there are exceptions, and those exceptions do cover personnel matters.
Mm-hmm.
So if you know,
Well, that's always one of the reasons I feel it's urgent that Dr. McNinch also be given a chance to speak this afternoon. I'm sure you intend that. Is that I certainly didn't come prepared to argue the case. However, it is the case that there are two fundamental issues here. One, what constitutes a public agency? And courts repeatedly throughout the United States have ruled in some cases that faculty senates were public agencies, in California, for example, where they were created by the boards of regents, and in other cases where they were not, that the faculty senates are not. That's one of the points. The other question is, if you are a public agency, do you get to hold executive sessions? The open government law seems to me quite clear on that point, that yes, you do, especially when you're considering appointments and especially where the privacy of nominees would be affected. We don't hold secret meetings. We never have held secret meetings. What we have done, as virtually every other Guam agency or affiliated body whom I've researched has done, is that we sometimes have executive sessions to consider nominees. One member of your council pointed out that even after executive session, you have to publish your minutes.
6
we
months.
do.
Yeah.
Of course we do. You have to announce the meeting in advance. Of course we announce the meeting in advance. The agenda is circulated prior to the meeting. There's nothing secret about these meetings. They have executive sessions in some cases. When Dr. McNinch asked the University Board of Regents to go into executive session, he wasn't asking them to hold a secret meeting. He was asking for a procedure that's both consistent with open government law, with Robert's rules, and their own rules. So we want the chance to make this case and to direct the council's attention to documents that have to be considered, including the American Association of University Professors' detailed statement about the harm that can be done by forcing a blanket application of open government laws to higher education. It causes widespread unintended damage on the ability to debate the merits of candidates for positions. And there is case after case after case documenting that fact. You need time to look at that just as we need time to summarize it. We didn't have that time because the rules kept changing and all we ever had was that 1 week window. That's all you have.
all right, thank you very much. So you want 3 weeks?
If the Faculty Senate Executive Committee doesn't kill me for not saying 4 weeks,
Okay. Well, it's up to you because you are the accused, and if the council, as vice chair of the subcommittee and vice chair of the council, I would want to err on the side of giving the accused the amount of time that they need to respond.
In addition, just so you know, the establishment of the Faculty Senate at the Guam Community College came from me, came from what I saw you guys do. So just so you know that. And the other ramification is this will have an impact on the Faculty Senate at the college as well. And it also may, as I hope everyone remembers when this first came up, I said the impact of this could also impact accreditation of the university and the college because of government interference in those establishments. We all know what happened years ago when that occurred, and everyone, both the college and the university, both almost lost their accreditation for it. So I understand all the implications, and I'm glad you said what you said. And I'm fine with 2 weeks or however long, because I'm glad you clarified that nicely to me about the elected versus the other and things like that. Thank you.
well, if I can just say one last thing.
Sure.
We are committed not only to following the law, but exploring its full implications. if it is the decision of the advisory council that even in full knowledge of how other systems of higher education have been adversely affected by blanket applications of open government laws, if it is the judgment of this council that nevertheless, on Guam, with GCC, with the University of Guam, that we should nevertheless open all such discussions to the public, considering the merits and any potential problems with the nomination, so we will do, especially if the advisory council's opinion goes on to be enacted as law. And we're all on the same page there that this is advisory. We want to do things exactly correctly and with utter fairness. We've never wanted anything else. So we look forward to a resolution. But let it be noted, there has been no such advice, there has been no such decision. There can't be a violation in an ex post facto law when there's never been any relevant decision. So we want to work with you. We want to supply all information that you would need to make an informed decision. Your recommendation is something that we will abide by, whether or not it becomes law. Okay? I think it should become law. Whatever is in the best interests of the territory, the students, the university, and all of its constituents, that's what we want to do. Okay? But let's get this decided on the full evidence and in consideration of all the issues. I appreciate the time that you've given me to talk with you.
Agreed.
In the resolution passed by the Board of Regents, there was a reference made to being in a resolution made by the Board of Regents with the establishment of the Faculty Senate, in if I believe Section 5, it refers to being in accordance with Guam law. So, yes. So you know, and we all want that too. So, thanks for...
All right.
We are committed to working with you.
Thank you.
Thank you.
I don't really have the authority to say 3 weeks since I'm not the Senate President, but if he doesn't kill me, you know, we can confirm that by
I
email
think
tomorrow.
3 weeks is reasonable. I think 3 weeks is reasonable.
Well, thank
so,
you.
thank you. We'll,
Appreciate it.
And before you
we'll
get up,
bring up Dr.
my apologies for the discourtesy. It was not intended.
Yeah.
It was just a result of a flood of other emails I was receiving and other work on my table. Also because we all were not quite on the same page functioning as an entire body, and I didn't want to commit the full council nor the subcommittee to anything that we couldn't fulfill. So my apologies.
I recognize that, and no one's accusing you of trying to be difficult or trying to derail our response. We're not saying anything like that at all. It's simply that we're not mind readers, so we needed to be told whether the case was still active or not. I appreciate the work that you're doing and all the hard work you put into it. We are behind the values involved in open government solidly.
Thank you.
Thank you,
But
Dr.
before I have to go, because like I said, I do have to go. Do we need to vote on
No, we're
the
not.
3 weeks?
Oh, yes, I think we do need to make a motion to, I'll bring up Dr. McNinch, and we've heard Dr. Smith speak, and so I would like to, before you leave, and Dr. Smith, I would just like to just advise you that while we realize that faculty are academia and that academia like to write very, very long papers, we are also speed readers here and editors, and we like to cut things to the chase. So just, you know,
If we can boil
please.
things down to 200-word abstracts, we can meet your 4-page
Okay,
restriction.
okay.
Well,
We
let me
can do
let me
it.
just let me just clarify. I don't
Right.
even think that anybody here on this council is opposed to reading what needs to be read. I know that especially the senators have to read voluminous amounts of material, but I think it's just once we receive a petition, it would be nice to have, or even a response, it would be nice to have the full compilation of materials at once rather than over a protracted period of time where we're getting
Yeah.
a bunch this week and a bunch that week.
It would be, yes, it would be helpful to have everything at one time.
You'll have it all at the same time. The only thing I want to recommend is between now and then, obviously we're not going to send you the AAUP's article unless you want us to do that. It's available online, interlibrary loan. I really want to recommend to the council that you read what the American Association of University Professors has had to say about the issues here. And that would go beyond the allowances for our appendix, but if you want us to put it
I
in,
will look it up and I will send the link to everybody.
much appreciated.
Okay.
Thank you.
All right. I just realized a point. If we give you 3 weeks, that's October 7th, then we need some time to look at it. So how about if your response is 3 weeks and we meet in 4 weeks? Okay?
Is that a motion?
Yeah, I'd like to make a motion that we give the UOG Faculty Senate 3 weeks to respond, which is October 7th. That would be your deadline.
As long as it's all right with Dr. McNinch. Total fairness.
And then we meet on October 14th. So we're going to have to have a week to speed read their responses.
There's a motion. Is there a
Seconded.
Second. There any
Okay.
objections? All those
Thank
in
you,
favor?
Dr. Smith. I'd
Aye.
like to now call up Dr. McNinch, and then we'll deal with
Thank
Mr.
you, Dr.
Rohr's
Smith.
complaints.
Yeah, motion passes.
October.
That week, yeah.
What is today? Today is Tuesday.
Yeah.
So Tuesday is October 7th, and Tuesday, October 14th, I believe. That's what my iPhone says. Okay. Good afternoon, Dr. McNinch.
Thank you, members of the committee, Senator Respicio and senators. Thank you so much for allowing me to talk to you today for a moment. Basically, I have just a couple of quick points to make. I have no issue with taking additional time. One thing that might help, and it would depend on whether the committee would consider it, would be I have no issue with continuing to talk with this group, maybe even up until December, so we can arbitrate or mediate it informally and hold some discussions on campus related to this, related to what's the best fit for everything. Now, if that's acceptable, then we might be able to craft a win-win policy all the way around in terms of how the open government law should apply and everything else. And I think that might be a suggestion. So I even have no objection, not even rushing after they turn it in, just hold the proceedings into abeyance until December, and that might give us some additional time to talk about these things. And I welcome and openly welcome talks to happen on this. I think that these talks are important. I think that the open government law is important. I think the open government law applying to the university as to whatever extent it's supposed to is important also. And so certainly I just wanted to mention that I have no issue with even waiting until
Extending it
December.
further.
And I'm going to make an open invitation to the Senate to have a nice on-campus discussion about these things, and maybe we can come up with some additional angles on it. Optimally, if we do that, I can simply withdraw my complaint, and then it's moot at that point. And I think that might be and that means that the process works. And I think that this process is working because people are talking now. And I wanted to thank you very much for allowing me to talk today.
Thank you, Dr.
Okay,
Rowe.
thank you very much. All right. Okay. All right.
You
Miss-
have the other two
Yeah,
complaints?
Mr. Rohr?
Yeah.
Would you like to come up and address your complaints, please?
Thank you. The first complaint does not accuse the legislature of doing anything illegal or even against its own rules. What it does do is appeal to this council, which is constituted to, quote, promote transparency in the government of Guam, and asks you to fix the situation wherein the legislature actually knows the agenda, but does not make it public. I understand that the legislature completely has the right to call session and to decide an agenda on the floor. That's not the issue. Would like to refer you to the PDN's report. Maybe the PDN got it wrong, and if they did, you can say so. It says senators will go into session today to discuss 3 bills and a resolution, but lawmakers won't say which ones. They won't be revealed until session begins. Now, this is the PDN's report. So it sounds to me that the agenda was known and for some reason was not revealed. I understand the legislature has the right to do this. My complaint to this council is in light of its commitment to promote transparency in the government of Guam. And so whereas in the future, if the legislature does know the agenda, and it's not like some secret emergency security thing, there is no reason to withhold the agenda from the public.
I think that your suggestion and your complaint are very valid, and I just would caution you that we are not a lawmaking body, so we cannot, all we can do is recommend to the legislature that they fix or that they adjust their rules to make known. And I also would caution you that sometimes, and having been a reporter and having had to correct something at one time or another, sometimes reporters do get things wrong.
Okay, and so did they get it wrong?
That is something you will have to ask the legislature.
Okay.
Yeah, Jane, I recused myself from this issue. I believe the other senators have, but if I can respond
Sure.
quickly as a respondent, as chairman of the Committee on Rules, I first want to thank Mr. Rohr for bringing these issues forward and to try to seek a remedy through the FOIA Council. At the time, there was discussion of, and I have to go back to the record, but there was discussion on 3 bills that may be on the agenda. It's pretty difficult to talk about what bills will be on the agenda, as Mr. Rohr knows, unless the agenda is adopted. As you pointed out, we have 2 ways of getting a bill on the agenda, and one is through the Committee on Rules, which all Committee on Rules meetings are noticed pursuant to the open government law. And then we have those instances where the Speaker calls session, the legislature into session, and by law, the Speaker has to do that with a 2-hour notice. If we go into session without an agenda being adopted by the Committee on Rules, the standard agenda rolls over, and that the committee on the main legislature on the floor would have developed the agenda at that point. You know, although there was talk of going into session with 3 bills, if I recall in that session, there were 3 more bills that were added to the agenda. So it's a very, I understand his point, and I agree that if ever the legislature goes into session without an agenda adopted by the Rules Committee, if there's any idea of what the legislature is going to session for, the public should be notified. But I caution that we could say that we're going into session for the following reasons and not even entertain any of those reasons, because that's just the nature of the legislative process, and that 1 or 2 members can't decide for the body or the majority what the basis of that session will be unless that decision is made while on the floor. So I couldn't commit to the media what we were going to discuss. All I knew was the Speaker's calling to session, and it was a Speaker who said she believed that there were going to be 3 bills discussed. But again, we ended that session with 6 bills being discussed. A couple of them were discussed that weren't even notified publicly prior to the going to session. But I agree with Mr. Rohr.
Mr. Rohr, I just want to clarify, both of your complaints have to do with the same issue, correct? Is that correct?
Well, I'd like to still separate them.
Okay. Sure.
So, if I'm not mistaken from what I hear, from what I'm hearing and reading, is that the Speaker called a session with about a 2-hour notice on June 11th. That's what happened.
Actually, more than 2 hours. I believe it was a day or so.
It was the day before.
It was the day before. Yeah, because it was in
Okay,
the
and
paper.
when she did so, at that time, there had been no agenda set. The Committee on Rules had no agenda, and it was the Speaker's call, which she has the authority to do as a Speaker to call session. Governor can too. And because of the call to session being, 24 hours or something, it's impossible to meet the deadlines as provided, though the open government law does provide for agencies to have call a meeting with less than 48 hours notice if it's deemed to be an emergency. So not knowing whether or not there was an emergency for these bills, but that seems to be what happened is the Speaker called, and then as we know, the PDN, part of our discussion earlier today, does not actually print things the way they really are. And when you read through
I don't
this,
think you can make that blanket statement, Barry.
you can quote me on that. I retract.
Sometimes.
Okay, they won't. To put here, they won't be revealed until session begins. That can be interpreted to the way the person wrote it, and I've had comments written about myself that are not what I said.
Yeah,
So I
for
know
the
that.
record, that was an inaccurate statement.
So I would say that, but again, the point Mr. Rohr is making is a good point. You know, we want this that's the reason for this council to have this discussion and come to resolution on this.
Yeah, I think it is a very good point, because you don't just call session for nothing. You know, someone has some idea, so.
And then again, too, I guess the agenda for this session is distributed once you go into session.
And it's uploaded
So even
on the
senators
web-
are left in question
But I
as to
think
what's on the agenda.
Mr. Rohr's point is that if
Mr.
someone
Barry?
wanted to come and be a part of the
Exactly.
process, they sometimes can't have 2 hours, only 2 hours notice if there's a bill being discussed that they are passionate about, that they may not be able to get off work or whatever, so.
Would that include an amendment to a bill that has not germane to the bill, that didn't have a public hearing?
That
But
does
those
happen.
Gotta get
but
that one
those
in.
are no longer allowed.
Yeah.
Oh, thank goodness.
Yeah, those are no
Mr.
longer
Rohr?
allowed.
Thank you. So, again, I probably wouldn't have even brought this up other than reading what the FOIA Council says that it was constituted to do, which is to promote. I know that you can't legislate,
Right.
but you certainly can promote.
And
So-
suggest.
And suggest. So I am simply asking that this council recommend to the legislature that in the future, that the people's business be, the people be apprised of the people's business whenever possible. We obviously understand there are emergencies. In this particular case, it didn't appear to be an emergency, which is what sort of flagged it. And so that's really just all that I'm asking in that regard, because we do want to be involved. We want to be here for the discussion. We understand that things can change on the floor, but whenever possible, do not leave the people in the dark. So my recommendation to the legislature.
All right,
Thank
well,
you.
thank you very much. Thank you for speaking with us today, and.
Well, the second one.
Sure.
We want to.
Mhm.
Okay. So the second one deals with something similar, where the open government law does require a 5-day working notice of the meeting, and the law also says that the legislature itself is a public agency whenever it holds a daily session, and we were only given 2 working days instead of the 5 working days prior to the session. Again, didn't do anything illegal. The legislature has complete right to do it. Again, I'm asking, unless it's an emergency, why not let the people have the proper notice? And so again, the same recommendation to the legislature to please set the example for the rest of the agencies in making this information available. But also, we have a persistent problem relative to all of this, which includes first of all, the lack of committee reports available in time for the session. I realize that, again, sometimes you don't even know what you're discussing, which is fine, but when you do know what you're discussing, the committee reports should be available to the public, and there seems to be a persistent problem with that. And then it's also a general problem with the ability of the public to examine the journal. The journal, by definition, is a daily record of events. We should be able to walk into the clerk's office at any point and ask to see the journal. I am on record of spending as much as 7 months to see just one page of one journal, and that's a true violation of the public's right to know. So I would like to see that the journal is made more publicly available.
Senator, are the journals online?
I believe they are, but I would have to check with the clerks to see what.
How far of a back? How much
but
of a
I
backlog?
again want to thank Mr. Rohr for bringing up these concerns, and a lot of which were problems of the past. We now have regular rules meetings that are duly noticed pursuant to the open government law, and agendas are set by the Committee on Rules. But more importantly, the legislature does not discuss any bills on the agenda unless the committee report is uploaded online. But there are times when the legislature either moves too fast or too slow, and we appreciate concerned citizens like him who step up and step forward and say, wait a minute, you guys may have overlooked this area or that area. I would check with the clerk to see where we're at with the journal but I believe that we've come a long way.
Okay, may I ask, is problems of the past, this actually occurred in June, so how, you're saying that things have been fixed since June?
Well, I'm saying that the journals may have been updated, but the problem of the past of discussing bills on the floor that have not been on the website have been taken care of. We don't discuss any bills unless it's been uploaded with a committee report, unless, of course, that public hearing is waived because of some emergency or some authority under the law that allows a speaker to do that.
So, just relative to the journal, again, it is a daily record of events, and Organic Act requires that to be publicly available. And so I understand that the journal in its final form may or may not be ready, but even so, a public citizen should be able to walk to the clerk's office and ask to see the notes, if nothing else, the notes, even if it's in the final journal. I have not been able to do that ever. It's always, we'll get back to you, never get back to me.
Oh, you're saying they don't release it unless it's been approved and...
They just don't even have it. They'll
Okay.
just say, "It'll get back to me." They don't. I've had to FOIA request it. Public citizens shouldn't have to FOIA request the journal. So I would just ask that they, whatever they have, be more responsive. I'm not looking for the final. I want to see
Okay.
what was discussed the day before. That's what a journal's for. And I should be able to walk over there today and see what happened in the legislature
just-
yesterday.
Okay, I completely
Senator,
agree.
point of clarification, who transcribes the journal?
The clerk does.
Okay, and it's
Yeah.
all typed, right? She's court reporter typing it, correct? So there's no,
And the journal,
Yeah,
as he said,
okay.
is correct, is a record of the communication that comes in, the bills that are introduced, where it's been referred to, resolutions that have been introduced and how it's been entertained, as well as what happens on the floor of the legislature.
so perhaps you
Right.
could just kind of move the process along a little
Yeah,
bit.
just keep raising the bar, and we'll
Yeah.
keep doing our best to try to achieve it.
Well, again, just simply, the problem that we had a few months ago was that the speaker understood the journal to be a transcription, and she said it takes time. Journal's not a transcription.
Yeah,
Okay?
yeah.
Just simply what you discussed
Yeah.
earlier about
Correct.
exactly what happened and
How
how
we
people's
conduct-
deep emotional feelings about.
Yeah.
And how we conduct our business here.
Right. And
Well, point of clarification here, it may be a transcription because if the person who's transcribing it is using court reporting, then they have to transcribe that from, and I don't know if they have an electronic
Right. No,
thing
but
to
in
that,
this
so-
particular case, it was a word-for-word transcription.
Okay.
And so I'm just simply
Yeah.
requesting that.
I'm not sure
Yeah.
how the process works, that's why I'm asking.
I kind of agree with what Mr. Rohr is saying. The journal, especially the journal, is an important document. I was just wondering if the clerk answers to the speaker or the secretary, legislative secretary. Who has the oversight of that person
Well,
and that
that's-
posting, or is that you?
Well, that's why I
The
get
Rules
to
Committee.
be on the chopping block, because it's Rules Committee also.
I'd give that to the secretary.
So, may I make a suggestion, Mr. Chairman, instead of, not to cut Mr. Rohr short on any points that he's making or anybody else, that we actually verify what at least the average procedure is at present and what we're talking about, and then just inform the FOIA Council, because that's something we should probably be made aware of anyway.
Yeah, I intend to submit my response in writing
Thank you.
for both you and Mr. Rohr to review.
Okay, all right, thank you very much.
Thank you.
We're ensuring that the public discussion is going to be part of the minutes.
It always is.
It always is, isn't it? Public discussion is part of the minutes, yeah. Yeah. All right, thank you.
Thank
All
you.
right.
Thanks.
The other question is, we're actually going into recess.
We were supposed to
No.
be going, we were supposed to adjourn, but I don't know, can we adjourn with
No,
a-
we're going to recess till 10 a.m. on Thursday, so hopefully we can adopt your proposal.
yeah.
Oh.
Okay, so I have to have this thing
Yeah.
done by Thursday.
Oh, okay, so,
I already sent him the previous procedures, switching out the...
oh, okay, right. So we have to meet at 10 a.m. Thursday to adopt the procedures, and then we are going to have a full council meeting again. Well, this is full council. We're going to have a full council meeting again on October 14th to discuss the UOG McNinch situation, which, as I now understand it, may be moot if he withdraws his complaint, which...
And I think
Yeah.
by Thursday I should have a written report of where Mr. Roar's complaint is, so maybe the
Okay.
FOIA council can give an official
Yeah,
recommendation.
okay. Well, in either case, even if both
Yeah.
parties withdraw their complaints because they're happy, we've done our jobs because we have... Tentative, okay. Okay.
Renee, wait, can I just call for a minute recess?
Sure. Okay, well, we've done our job.
Well, you know,
Yeah.
I think so.
Yeah.
So how long are we going to be on Thursday?
Less an hour. Thursday, can we do this in an hour? Gentlemen?
Okay, we'll reconvene. Before we recess, I'm sorry Mr. Roar left, but I'd like to give an opportunity to our legislative clerk to give us a quick synopsis of Mr. Roar's concerns and where we're at with both the Legislative Journal, and if the public is able to come in and at any given time ask for any business that happened in the legislature.
Yes, they do. Anyone who...
Madam Legislative Clerk, can you identify yourself for
I'm
the
sorry.
record? Thank you.
My name is Renee Mano, and I am the clerk of the legislature. Basically, the journal has been an ongoing process. It's something a little different and from what's been practiced from the last term. So every session date, we all have it available should the general public request for a journal. Last week, we had maintenance problems with the website. And what happens is that I don't know if anyone has gone through the website and looked at the journals. It's not just efficient, but it's convenient for one to use, and that is you go into the journal and it's linked to
The bill
documents.
number or the document.
Yes, so any document that is presented during session, it's available from messages and communications to the bills, discussion, the bills that were discussed, actions, procedures that was done within the session floor. There are some documents that are quite large, or as long as it pertains to the 32nd Guam legislature, that this term, it's available. Yeah, if you would call for a past journal, then that's something that we would ask that you give us time to compile, and we will present it as soon as we can.
Let me ask you this, Ms. Mano. Is whoever is transcribing the session, are they using shorthand to do it? I mean, is court reporting kind of shorthand typing, or do they actually type out what people say?
Yes, well, this term, I was given the opportunity to attend a conference in Sacramento, and I was able to learn a lot of skills for the legislative clerk's office, and one of it was the transcribing, the verbatim, and the shorthand. At this point, in any of the legislative branches, none of the shorthands is being practiced. So you would see again that there's a difference with the journals as far as procedures on the session floor. You wouldn't see, unless there's a floor amendment passed or a motion, then you would see that it's based on just procedures from the speaker recognizing individuals. If you want a copy of the tape or an audio recording, that is what's available. Then it would leave the opportunity for the general public or the one requesting, the individual requesting for transcription. It will give them the opportunity to contact the...
Okay, so I understand now that just the procedures are available in print form, but the actual discussion is on tape. So if someone requests the actual discussion, that has to be transcribed, right?
Yes,
Or
or they
the
are,
DVD could be provided.
the DVD will
Yeah.
be provided.
Ah,
yes.
okay. Well,
That-
that,
Sometimes we ask
yeah.
them to bring a DVD and then we'll copy
okay,
it for them.
all right.
Yes.
And can we let Mr. Rohr know that?
He knows that.
Oh.
He
He's-
does,
Yeah.
and
Okay.
he has been in.
Yeah.
Yeah,
He has
I-
been in communications with me,
Okay.
and anytime he requests for something, I would present it to the COR chair and the rules chair, and then it's always available to him.
Okay, all right. Well, we appreciate your work. Thank you very much.
Thank you.
Thank you. Okay, so we'll recess
We are
till
recessed? Yeah.
Thursday, 10 a.m.
Okay.
Thank you, everybody.
I don't think we can have a...